Okay, thanks for joining. I'm Samar. I'm an immigration and global mobility partner at Spencer West. And today we're going to talk about the new right to work check processes. So those of you who have attended my webinars before will know that I do like to have a very interactive, engaged session. Now, I find that the polls kind of slow things down. So what I would ask you to do is to please pop your comments in the chat insofar as possible. You can put questions in there, and then also I'm going to be asking you questions, and you can pop those in there too. The session is being recorded, so keep that in mind. And otherwise, I think that is that's the housekeeping out of the way. Let's get started on this great webinar that I've prepared for you. So today I'm going to talk to you a little bit about the framework of illegal working first, and then we'll talk about how to do the checks, so the nuts and bolts of it, and what evidence to keep on file. So do let me know if you have questions as we go along. If it's a bit off topic or I'm going to get to it later, then I would ask you to just be patient and wait maybe till the end of the session, or email me afterwards. My contact details will be at the end. So can I just check before we get started, everybody can hear me and you're all ready? Okay, looks like that's fine. So what is illegal working? Well, it's when somebody's working and they don't have authorization to work. Now, it doesn't necessarily mean that they have no right to work in the UK. That's something to keep in mind. It could be that they don't have the right to work in the UK, or that they don't have the right to undertake the work in question, okay? So there might be limits, conditions on their right to work in the UK, and that might relate to the number of hours that they're allowed to work. So for example, many people who are on student visas can work 20 hours a week during term time. And so that's a limitation on their hours. You couldn't hire them for a full-time job during term time. It might have to do with the type of vacancy. So again, students are not allowed to fill a full-time permanent vacancy, even when they are allowed to work full-time, say during vacation times, holiday times, or after the completion of their course, but before expiry of their visas. And then probably most important for those of you on the call whose organizations have sponsor licenses is that the authorization to work can be specific to a role. Okay, so sponsored workers, whether that's skilled workers or the new senior or specialist workers who've replaced that route has replaced intercompany transfers. They are authorized only to do the work for which you've sponsored them, as reflected on their certificate of sponsorship. Now, one thing that happens really easily, all too easily, is that a worker will be sponsored for a particular job, and then the job will change, and the certificate of sponsorship is not amended or updated. There's no report made. That person is working illegally if their job changed and that hasn't been accommodated on the sponsor management system. So that's something to watch out for. That's why the sponsor recording duties are so important. But this isn't a webinar about sponsorship. So let's talk a bit more about illegal working. What are the consequences? Now, My style of advising is not to scaremonger people, but you do have to know what the potential consequences are. So it is a criminal offense to employ somebody who's not authorized to work or to undertake the work in question. And that can result in 5 years in jail or an unlimited fine. Other criminal penalties include the closure of business premises. So an immigration officer can come to the premises, close it down for up to 48 hours, during which time they have to go to the judge, and the judge can order a business premises closed for up to a year, which for many businesses is basically, the death knell for that business. So it's very significant. Judge can also give a compliance order, which is basically, he could say, oh, the organization has to check right to work on a, on a monthly basis or every 3 months, or similar requirements to help ensure illegal working is prevented at the organization. So, that legislation is in place, but honestly, anybody on this webinar is showing sufficient interest that it's very unlikely to be found criminally liable. And it's really rare that the Home Office does exercise actually any of those powers. They've been encouraged to exercise the closure of premises powers a bit more. And so that might happen in future. But I'm obliged to tell you about the criminal penalties, but I would urge you don't really worry about them. Civil penalties are a more realistic outcome for illegal instances of illegal working that might arise in your organizations. So civil penalties include an on-the-spot fine of up to £20,000 per illegal worker. That can really add up very quickly if you have systemic issues that mean that several people are working illegally. And other potential consequences are ineligibility to apply for a sponsor license to sponsor non-UK nationals to work in the UK. That's if you don't already have a license, or revocation of a sponsor license if you do already have one. Also, the Home Office publishes on the gov.uk website the names of all the businesses that have been found liable for a fine and the amounts of those fines. So there's this kind of naming and shaming going on. Okay. Now, although it is a criminal offense to employ an illegal worker, there is no positive obligation under the law on employers to check right to work documentation. So really the right to work checking that we're discussing today, the benefit of it is that you are going to be avoiding penalties and avoiding a risk of you're avoiding civil penalties and avoiding risk of criminal liability as well, or any of the criminal penalties. So if you check people's right to work according to the Home Office guidelines, then you will benefit from a statutory excuse to those civil penalties of up to £20,000 per instance of illegal working, okay? And although the right to work checking framework doesn't excuse you from liability for criminal penalties, it is, almost, there's like a 0.01% chance that you would be found liable for criminal penalties if you're actually checking everything in line with the government requirements, and you don't then actually come to know that somebody is in fact working illegally. If you know somebody's working illegally and you continue to employ them, then you are at risk of criminal liability, regardless of what checks you've made. But in practice, otherwise, although the framework doesn't excuse you statutorily from criminal penalties the way it does for civil penalties, in reality, in practice, you're really reducing your risk to pretty much nil if you do follow the right to work checking processes, and you don't then come to know that somebody is in fact working illegally. So we're going to discuss today 3 ways of checking the right to work, which are now available to UK employers. So you can do an online check using a share code. You can do a manual check of specified documents, or you can use an identity service provider. Now, which method you use will depend on the type of status and documentation that you're presented with, as well as your own business considerations. And we will revisit this kind of overview to think about how you make those decisions a bit later in the process. So I'm now going to launch into the nuts and bolts of how to conduct checks in each of these ways. Before I do so, does anybody have a question? You can just pop it in the chat if so. But I am likely to address whatever questions you might have at this point later on. But if you have any questions about the kind of framework or liabilities, now might be a good time to raise those. No? Okay. So in terms of the basic requirements, you must check right to work of all new employees before they begin employment if you want to benefit from the statutory excuse from civil penalties, okay? So everything we're talking about today is the framework to benefit from the statutory excuse from civil penalties, the Home Office guidance on how to conduct checks so that you benefit from the excuse, okay? So first of all, you have to check the right to work of all new employees before they begin employment, okay? And if you're doing that on the first day, that's okay, but make sure that there's documentation that that's the first thing that you did with the worker that day. So for example, there might be a new joiner checklist, and right to work check is right up there at the top of the list, okay? They can't do anything else if you're doing it on the first day. If otherwise you can do it before their actual first day, before their start date, and then it will be more evident that they didn't begin work and that you benefit from the statutory excuse. You also have to recheck the documentation or the permission of every employee who has shown a temporary permission to remain in the UK or temporary permission to work in the UK. Okay, you're going to need to recheck to maintain the statutory excuse. And we'll talk a bit more later about when you recheck various permission holders. Now, what are you checking? So regardless of the different types of checks you can do online or manual checks on documents or using an identity service provider, there are certain things that are going to be common to all checks that you need to do. So is the worker authorized to do the work in question, as we just discussed a few minutes ago? Have the expiry dates of their permission passed? Okay, is their permission to work current? Also, the photos or images of the person and their date of birth, are those consistent with the person's appearance? Okay, because if the Home Office comes to visit and they find that you've checked somebody's documents, but the date of birth or the photo is not consistent with the person who's actually presented themselves for work, then you're not going to benefit from a statutory excuse. Okay, so let's get into the nuts and bolts of how to do the checks under each type of check that you might be able to do. And first, we're going to talk about what are called online checks, okay? And that's when you use a share code that's generated by the employee to verify their right to work. Now, I would urge you to use the share code system whenever possible. It's not going to be possible for every individual. We'll see that not everybody can generate a share code to demonstrate their right to work in that way. But where it is available, I do think this is the best option for employers. Now, please listen closely. If there is one thing I want you to take away from today's webinar, it is this. You can no longer check physical biometric residence permits to benefit from a statutory excuse from civil penalty, okay? You must check biometric residence permit holders via the online share code system. I'm just going to repeat that. If you are presented with an original biometric residence permit, or BRP, you cannot use that physical document to conduct a manual check and benefit from a statutory excuse. Does everybody understand that? If anybody doesn't understand what I've just said, please do speak up, because it's very important. As I said, this is, if you're going to take away one thing from today, this is it. All right, doesn't seem to be any questions on that. So the major change that happened on 6th of April is that for BRP card holders, as well as biometric residence card holders, you must use the online share code system. Also, for those issued status under the EU settlement scheme, they're only going to have digital status, or and so you have to check them under using the share code system. Frontier worker permits as well. They might have a card or they might not, but you have to check them using the share code system, okay? I've gotten a question in the chat about ID service providers. We'll get to that later, if that's okay. So just hold on to your thoughts there, and we can address that later in the session, if that's all right. Going back to the share codes, there are now lots of people who are only going to have what the Home Office is referring to as e-visas or digital status. And so you will necessarily have to check their right to work using the share code system. They're not going to have documentation to show you. You mustn't assume that that means that they don't have permission. It's more and more common as the Home Office moves everyone to their digital systems that people will not have physical documentation of their right to work in the UK. So that might be a worker who used a biometric residence permit and the UK immigration ID check app when they last applied. So that app allows people to verify their identity by reading a chip in their passport or reading their or entering details of their BRP card and scanning an image, rather than going to an appointment to submit a digital photograph and finger scans. So it can kind of be quite useful in the application process. And those who are able to are often using that system. They will have e-visas. An EEA national is likely to have digital status or an e-visa, or a British national overseas. So for example, Hong Kong, people from Hong Kong might have that type of e-visa, as they will have used this ID check app. Any questions so far? I'm going to get into how you actually go through the share code process. So first, the individual gives you permission, okay? And basically they do that by generating a share code and sharing it with you. So they enter their details at that gov.uk page at that URL there, gov.uk/prove right to work. And I will say it can be a bit confusing once you get onto the gov.uk site, which service to use to evidence right to work, because there is a service that the individual can use just to access their profile, and they might access their profile and print it out and provide that to you as their documentation of right to work. But that is not sufficient documentation for you to check and then be eligible for an excuse from civil penalty. Okay, you need to ask them to generate a share code at that URL there. When they receive the share code, it should be valid for 90 days. It used to be a shorter period, but I understand they're now valid for 90 days. And since the 10th of January, the share codes that are generated specifically to prove the right to work will start with a W, okay? So since the 10th of January, if you use a share code that doesn't start with a W to conduct the check, then you're again not going to benefit from the statutory excuse from civil penalty, because it will mean that it was a different service that was used that is not in line with the Home Office requirements for right to work checking. You know, there's a service, as I said, for the individual to access their profile. There's one for individuals who are trying to show their right to rent in the UK. And these will all start with different letters now. So you want the share code that starts with a W. If they then generate that share code, they need to provide it to you and provide you with their date of birth. And then you can undertake step 2, which is to access their right to work profile online. So you go to the gov.uk page with the URL ending in view right to work, and you enter the share code and their date of birth there. Now, when you do this, you have to be in the presence of the employee. That can be in their physical presence, or it can be via a video link. The Home Office is happy for you to look at the online profile information and look at the person via video link to verify that it's them and that they have the right to work, okay? So what you will see if the online check is a positive online check indicating the right to work is a confirmation that they have the right to work in the UK and the end date for that permission, if there is an end date, or it will say that they have the right to work in the UK indefinitely, okay? It will also have a photograph of the individual. So again, what are you checking in terms of the photograph? Can anybody tell me in the chat, what are you looking for when you go on the online check? You're having a video conference with the person. You're also looking at their right to work profile at the same time and the photograph of them. What are you checking in the photograph? Does anybody know? If anybody has a guess, please do pop it in the chat. Yeah, exactly, Victoria. Thank you. It has to look like the person who's presenting themselves for work. You know, you're also looking at the date of birth, seeing is that consistent? And the positive online check will also show the date of the right to work check, which is obviously important because, as I said, you want to show that you've done it before, you've done the check before you hire someone, and if their right to work is temporary, you want to show that you've done the recheck at the appropriate time. So before expiry of their visa or permission, and then you'll continue to benefit from the statutory excuse. Okay, so any questions on Share codes, before I move on to manual checks. Any questions on share codes, using the share code system? I think it's the best system, and I would encourage you to use it. So if you have any, if you're uncertain about any elements of how to use the share code system, let me know. Nope. Okay, let's talk about the manual checks. So the manual checks are probably how people think about right to work checking, you know, that somebody shows up, you know, physically shows up in real life and presents you with an original hard copy document, and you check that for their right to work. But I think it's going to be less and less common. Basically, with manual checks, the documents have to be checked in the presence of the holder, and you need to be in physical possession of the original hard copy documents. Now, there is a temporary COVID policy, which we'll discuss in a minute, that allows you to check copies, but generally, you have to be in physical possession of the original hard copy documents. And then in terms of the person, you can be checking them in person or via a video link, as long as you have the original documents. So for example, a worker could post their original passport to you, and you could check their right to work then holding the original passport up whilst you're having a video call with them, okay? Now, under this temporary COVID-19 policy that they keep extending, and is now extended through 30th of September 2022, you can check copies of documents by video call. So the way that would work is a worker sends you a scanned copy or even a photo via email or a mobile app, and then you arrange a call with the worker, and they hold up their original document during the call. You compare that to the copy that you have, okay? We'll talk later about record keeping of these checks. And if you are using this temporary COVID-19 policy, you have to keep a record of it in a certain way. So just keep that in the back of your mind for now. Now, when you are looking at you know, physical documents, one of the things you have to do is to ascertain if that document is genuine. Which can seem scary, but the standard of verification is just that someone who's not trained in the identification of false documents and who's examining it carefully but briefly and without the help of technological aids would be expected, you know, could reasonably be expected to realize that the document in question is not genuine, okay? So you're looking for things like, you know, is the lamination peeling? You know, has something been kind of written over, say on the passport details page? That's the kind of thing you're looking for. You're not expected to be an expert in fraudulent documentation. One thing to do is to explain, to get documentation to explain any discrepancies in the names of documents that you're shown. So we'll look at the specified documents that are acceptable for manual checks in a moment, and you'll see that some of them are combinations of documents. So you have to provide, you know, two things to satisfy the document check. If there are any discrepancies in the names there, or in the name, you know, the person is presenting themselves with, then get some extra documentation to explain why that might be the case. So for example, a marriage certificate or documentation of change of name by deed poll. Okay. So let's talk about the acceptable documents, unless there are questions. All right, let's talk about the acceptable documents. So there are a couple of different lists of the acceptable documents. List A, which we'll look at in a moment, is a list of the documents that will provide a statutory excuse for the duration of the employment. So let's say you're recruiting a new worker, you're doing the check the day before their start date, and they present you with a list A document, you check it properly, etc. So when would you need to recheck that document or recheck their right to work for that individual? Can anybody hazard a guess? in the chat? When would you need to recheck a document that's on list A? You've checked it before employment. No, no guesses? So if somebody presents you with a document from list A and you check that before they start employment, then there's no need to recheck that person's right to work in the UK. That you will have established a statutory excuse for the duration of their employment. You know, your work is done in terms of right to work checking for them. Now, there is another list of documents. And again, we're going to look at these in a minute, so you have a bit better understanding of the documents that I'm talking about. There's another list, list B. Documents on list B reflect a temporary right to work in the UK, okay? And list B is divided up into group 1 and group 2. All right, and you have to recheck group 1 documents before they expire. Group 2 documents, you have to take a bit of an extra step and use the employer checking service on gov.uk to obtain what's called a positive verification notice, or PVN, which will establish a statutory excuse for the duration of validity of the PVN, which is 6 months. And so you would have to recheck those documents before the end of that 6-month period during which the PVN is valid. So Susie K asks, what if their passport expires during their employment? Do you not need to have seen the new passport? So Susie, I think you're talking about a list A document, but we'll look at which passports are list A in a minute. If you are looking at a passport that's on list A, then it doesn't matter if that passport expires. You will still benefit from the statutory excuse for the duration of the employment. Okay. Now, just need to make sure I'm able to proceed. There we go. So, okay, great. I think that's answered Susie's question. So let's have a look at the lists themselves, okay? This is list A in all its glory. This is the complete list. It's a bit shorter than it used to be, and we'll discuss why that is in a moment. So you'll see that on list A is a current passport or an expired passport showing the holder is a British citizen or a citizen of the UK and colonies and has a right of abode in the UK. So, you know, to take Susie's question a bit further, even if the passport is expired when you first view it, if that's a British passport, that's okay. All right. Now compare number 4 on the list, which is a current passport endorsed to show that the holder is exempt from immigration control or is allowed to stay in the UK indefinitely. Okay, so this is a non-British passport with an endorsement in it that says the person is allowed to stay in the UK indefinitely. Okay. And that does have to be current. Again, if it's current when you check it and it shows an indefinite leave to remain, it's a list A document, it doesn't have to be rechecked before expiry of the document, of the passport. So I'm not going to discuss each of these in detail, but there, you know, there's the full list for your reference. And you'll see a certificate of naturalization is on there. A current immigration status document indicating the person's allowed to stay in the UK indefinitely, together with a national insurance number, a document showing their national insurance number. So this is one of those combinations of documents that I was talking about earlier, where you might need to obtain documentation reflecting an explanation for a discrepancy in the name. So this is list A, where you only have to check it once, and the statutory excuse is maintained for the duration of employment. So let's look at, does anybody have other questions on list A? No, okay. Let's look at list B. So as I said, there are two groups in list B. There's list B group 1, which is a current passport, which includes a current passport endorsed to show that the holder is allowed to stay in the UK and is allowed to do the type of work in question, but there's going to be an expiry date on that endorsement. Okay, it's not going to say that they can do it indefinitely. And then there are provisions for territories in the common travel area, documentation issued by them, or a combination of documents again. So an immigration status document together with the national insurance documentation. Now these documents that, as I said, will show an expiry date of the right to reside and right to work in the UK. List B group 1 documents need to be rechecked before the date of expiry. Okay, so you're going to be setting a calendar reminder that you can point to when the compliance officer comes to visit to show that you have scheduled a recheck before date of expiry if you're shown a list B group 1 document. Any questions on that? Okay, let's talk about list B group 2. Okay, so list B group 2 is that special category of document where you need to use the employer checking service. It is quite a straightforward online process where you submit details of the individual and of their the documentation they've provided or their circumstances, as the case may be, and request verification of their right to work in the UK. Now, one thing I will say is that the employer checking service says that their turnaround time is 5 working days. In fact, it can take much, much longer. Also, they're not very good at the nuances. So, you know, for example, there's a special rule allowing students, people who are switching from a student visa to a skilled worker visa, to start work from the date of submission of their online application for permission as a skilled worker. And the employer checking service is a very kind of technical point of law. They're not very good at that kind of thing. So the person, you know, does have the right to work, but you're going to kind of have to explain it to the employer checking service. And worse, you're going to have to wait for them to kind of ask you for details so that you can explain it to them, because there's no way of providing that on the employer checking service form. So just keep in mind that, you know, it is going to be longer than 5 days, particularly if it's a bit of a technical special case. But generally, it's a system that works fairly well. And you could use the employer checking service if you're shown a document that's known as a certificate of application. So that's a document that people are going to get if they have applied for the EU settlement scheme. Okay, you can use it if the worker has said that they have an application pending. So where somebody's leave is expiring, as long as they apply for further permission before the expiry of that leave, they will benefit from an extension of the conditions of their previous leave. So for example, if let's go back to the example of the student who's applying to switch to skilled worker. Let's say the student's course has terminated, and so they're able to fill a full-time they're able to work full time, as long as it's not filling a permanent vacancy. So, you know, they're subject to a specific contractual period. Now, they, let's say their student leave is expiring tomorrow. As long as they submit the skilled worker application today, those conditions allowing them to work on their student visa, those are extended whilst the application is pending. I've just realized this is a really bad example because actually they can fill the skilled worker role according to that technical point in the immigration rules. So actually, let's talk about somebody on a spousal visa. Okay, they can work. They have no conditions on their right to work in the UK. They can work as an employee. They can work as self-employed. Let's say their visa is expiring, their spousal visa is expiring tomorrow. They're switching to skilled worker. Whilst they're waiting for the skilled worker application to be approved, they can still work as a self-employed person or in employment. Now, once the skilled worker application is granted and the start date on their cause starts, then they would no longer be able to work in self-employment because it's a condition of the skilled worker work authorization that they only work in the specific role for which they are sponsored. So sorry, that was a bit confusing, but I hope everybody's clear on conditions of leave continuing whilst you're waiting for an application to be decided, as long as you've submitted it before the expiry of the current leave, okay? That's a legislative provision, and it's named, the type of leave is called 3C leave after the provision in the legislation. So if you have somebody who indicates that they've made a further application and so the conditions of their leave are continuing, you can use the employer checking service for them and obtain a positive verification notice so that your statutory excuse continues for 6 months. If their application is going to take longer than 6 months to process, you would get another positive verification notice at that point. Does anybody have questions on that? I appreciate it wasn't, I had to backtrack a bit there, so it might have been a bit confusing, but are you clear on it? Let me know if not, please. Okay, seems like it's okay. I'll just say one other thing about the employer checking service before going on to identity service providers. If you are needing to use the employer checking service for somebody who's already an employee in order to verify their right to work, then you will benefit from a 28-day grace period during which your statutory excuse is maintained whilst you're waiting for the employer checking service to get back to you. So let's say you have somebody who has that spousal visa, their leave is expiring, they tell you they've submitted an appeal, but they only tell you like the day before their leave expires. So you submit an employer checking service request on that day before their leave expires. You know, you don't have documentation in place otherwise to maintain the statutory excuse, but your statutory excuse is maintained for 28 days to give you time to get that positive verification notice. That does not apply, the grace period does not apply to new hires, okay? So for a new hire, you do have to wait for the positive verification notice before you can go ahead and have them start in their employment. Otherwise, you don't benefit from the statutory excuse, okay? So let's talk about identity service providers. So this is another, you know, big exciting news in the changes to right to work check processes that were introduced on 6th of April. So the Home Office has introduced this framework to allow use of identity service providers to check current British passports and Irish passports, and also Irish passport cards, by the way. Okay. So an employer can engage an identity service provider to check current British passports, current Irish passports, and current Irish passport cards. And the benefits are, or the advantages are that physical possession of the documents isn't required. So since 6th of April, you will benefit from a statutory excuse if you correctly use the services of an identity service provider to check these types of documents. So how does this work? Well, basically, the identity service providers are using what the Home Office refers to as identification document validation technology. And that is a device that's going to scan the document, and then it's going to use that scanned image and it will compare it to databases it has of acceptable documentation. So let's say somebody presents a Ghanaian passport as part of their right to work check, and the checking service provider is going to have examples of what a Ghanaian passport is supposed to look like, and it's going to be checked digitally against those examples. And then the service provider will provide an authenticity score, which will indicate either it is satisfactory or it's not. Now, although this was introduced on 6th of April, this system isn't actually operational yet. So you can't actually engage an ID service provider yet to do this. There's going to be a certification framework for these identification service providers, where the Home Office is going to certify some of them as following their processes. And the Home Office is encouraging employers to use those identity service providers, who are certified, but you're not required to use an identity service provider who's certified, okay? You can use a non-certified one, but we'll see in a moment that there are advantages to using a certified one. We also don't have a lot of visibility on the fees that they will charge. So some very early documentation that came out when the Home Office was presenting this, well, really proposing this method of checking, indicated that the charges that identity service providers would apply per check could be between £2 and £70. And the impact assessment that the government published in relation to this change indicates that they expect the charge to be less than £1 per check. So there's really actually very little visibility on what the actual fees might be. So what the identity service provider is going to do is they're going to record the details of the individual's identity. So, the same type of details you would expect to find on a passport personal details page, date of birth, location of birth, that type of thing. They're going to record an image of the individual's documentation and an image of the individual themselves. They're going to confirm to the employer the verification of the individual's identity and the date of the check, and provide a record of all the elements of the check to the employer. Now, I don't think this system is actually going to be very useful. It could maybe be useful for the most, like really large corporations that have huge volumes of employees that they're checking all the time. But keep in mind that you're not just kind of outsourcing all responsibility for verifying right to work if you use an identity service provider, okay? There's still employer due diligence to be done. And this is an element that I don't think the Home Office has actually thought through very well. So you have to be satisfied that the identity service provider conducted the check in the prescribed manner. You're responsible for obtaining the check from them. So if you ask them for a check and they don't provide it and you don't chase them, that lies with you. You're not going to benefit from the statutory excuse. You might have a contractual claim against the identity service provider, but in terms of the Home Office, you are liable. And you still have to check that good old checks that are applicable regardless of the type of check that you do. You always have to check that the image of the person and their ID details, like their date of birth, are going to be consistent with their appearance. Okay, so that's pretty much what we know about identity service providers. There was a question about this earlier in the session. I am going to just continue now because we're running out of time. But if you have any questions, please do email me. I'll give you my email at the end. I just wanted to make a note about students. So students are a bit of a special case. I mentioned earlier that they're allowed to work 20 hours a week during term time, and then full-time outside of term time and after their course ends, whilst their permission is still valid. So, that means in practice, you're going to have to do a bit more work. And, it's actually said explicitly in the right to work check process guidance that the Home Office wants you to follow to establish a statutory excuse, that you do have to take a few more steps with students to verify when their term and vacation dates are. So it can be a printout from the university website, or an email addressed to the student about the dates of their course, or a letter addressed to you about the dates of the course. Okay. And I just want to revisit, now that we've talked about them all, the 3 different ways of checking the right to work. So using the online check, using a share code to do an online check. So that's only going to be available for certain non-UK national workers. So a British passport holder is not eligible to generate a share code. And you can check that by a video conference. Until the end of September, you would need physical possession of the documents to do it by video conference. Until then, you can use a copy. Then there are the manual checks on specified documents. And under a COVID-19, the check by a video conference for the share code system, that is going to be allowed indefinitely. So that's not a temporary policy. The temporary policy relates to the manual checks, okay, where you can check a copy by a video conference through 30th of September 2022. But after that, you're going to have to have the original document with you. The identity service provider checks allow for remote checking of only of British passports and Irish passport cards, and they have to be current. So for example, if somebody has an expired British passport, how are you going to conduct their check? Can anybody hazard a guess? Somebody has an expired British passport. What's the way you're going to conduct their check? Well, you're going to need to do a manual. You're going to need to follow the manual checking processes for them to establish the right to work in the UK. It is an acceptable document. An expired British passport is an acceptable document to establish the right to work in the UK under the manual checking system. But let's say this person joins you, you're doing this check after 1st of October, on or after 1st of October. You're going to have to ask them to post that to you, or they're going to have to show up in person and give you their original passport so you can do the check. Okay. So just something to consider. I just wanted to highlight these different ways of checking passports now that we've talked about them a bit, because people are very nervous still. Some people are very nervous about COVID, or they're vulnerable. A lot of you are dealing with managing hybrid workforces. So consider how you're going to do the check. Do you need to do it in person? Do you need the original documents? And how you're going to communicate that to the employees. I also wanted to just highlight that the old documentation for EEA nationals' family members is no longer valid. So these individuals should have applied for the EU settlement scheme for permission under the EU settlement scheme. The deadline was 30th of June. If somebody has this type of leave, you would see an endorsement in their passport residence card, or an EEA family permit, which is different to an EU family permit. And so these documents have been removed from the list of acceptable documents. The post-Brexit document checks can be done on EU family permits as a physical document, and then non-EU national family members of EU nationals will have BRP cards, so you can check that via the share code system. Now, late applications are permitted to the EU settlement scheme. So if you come across anybody who still only has the old style documentation, they do need to apply, and please get in touch with us as soon as possible in those situations so we can sort out their status. Ukrainian nationals, I won't go into it because I'm cognizant that we're over time. Sorry about that interruption earlier. So Ukrainian nationals, basically, they're going to have documentation that's going to fall under one of the lists. But if you have any specific questions about checking Ukrainian nationals documents, just get in touch. It is a bit confusing because the schemes changed as the war progressed. So if you have questions, just let me know. So let's talk quickly about keeping the right to work evidence on file. So you've done these lovely checks, but what it's really going to come down to is whether you can evidence to a visiting Home Office compliance officer that you've done the correct checks. That's where, that's where the statutory excuse is going to be established. So in terms of format, you can keep the evidence in hard copy or in JPEG or PDF. And you have to keep the documentation for the duration of the employment and for a further 2 years after the end of the employment. And I'll just quickly note that the requirement to hold documentation for sponsored workers is a different duration, but for right to work checks, it's the duration of the employment and a further 2 years. So the type of documentation you need on file to evidence that you did the check will depend on the type of check that you did. So for manual checks, if you're copying a passport or scanning a passport, you need the personal details pages and any pages with UK government endorsements, including the current right to work endorsement, if applicable. If it's any other document, you have to copy the whole document. So for example, for a biometric residence permit, you have to copy the front and the back, otherwise it will not establish a statutory excuse. And if you're keeping hard copies, then write on the hard copy the date on which this right to work check was made, and then insert the date. Unfortunately, if you just sign it and date it, the Home Office does not accept that as evidence of the date that the check was made. I know that it's accepted, in all kinds of other fora and circumstances as the actual date something was done, but the Home Office wants you to write out, this is the date on which the check was made, and then write the date. And if you are checking by video call, if you're checking copies of the documents by video call under the COVID-19 policies, then you have to make a specific note that you've undertaken the adjusted check due to COVID-19. And then you sign and print your name. Now, as I said earlier, you can keep JPEG or PDF files or hard copy. So if you're keeping digital records only, obviously you're not writing on them. Keep a separate spreadsheet to record the date that you've done the check for each individual, okay? And rechecks, obviously. If you've been doing the online checks, then you'll be able to just print the profile page and save it, or you can save the PDF digitally to file. For identity service provider checks, you need to retain the information provided by the identity service provider. But as I said, the Home Office hasn't really thought this through, because they are requiring employers to verify that the person's appearance matches the information given in the record provided by the identity service provider. So I think it's worth actually keeping in a spreadsheet that you've checked that. More to remind yourself to actually look at the details provided by the service provider and assess whether they are consistent. If the Home Office shows up and they find that the person's appearance doesn't match the details, the image or the date of birth, etc., provided by the service provider, then you will not benefit from a statutory excuse. And if that person's working illegally, you could be subject to a fine. So that is it for right to work checks. Again, I'm sorry about that interruption earlier. I am hosting another webinar within the next few weeks, maybe in about a month's time, on the new immigration rules and specifically the new routes for businesses to use in sponsoring workers or hiring non-UK nationals to work. So please keep an eye out for that. If you don't receive my newsletter, then you can stick your email in the chat now or email me. My email's there on the screen, and let me know. I'll add you to the newsletter. That's where the invitations to the webinars will come. If anybody has any other questions, now would be a great time to let me know. Any other questions? I appreciate we've run over time. Thank you so much for your time. And if nobody has questions, I'll just say thank you again, and I hope to see you at another webinar soon. Bye, everyone.